This program is brought to you by Emory University.
The next panel is more so a discussion between Professor Mindy Goldstein from Emory and Professor Percival. I'll let them introduce themselves and sort of jump right into it.
Hi, everyone. My name is Mindy Goldstein, and I'm an environmental law professor here at Emory Law School. I run the environmental law program and the Turner Environmental Law Clinic, which is a public interest environmental law firm housed out of Emory. I've been here for 10 years. Before that, I was an attorney in private practice representing commercial real estate developers and assessing environmental liability and land use transactions. But I'm really excited to be here today to have a conversation with Robert Percival, a professor at at University of Maryland. I wish he was at Emory. Bob, is it okay if I introduce you?
Sure.
Cool. Bob was my environmental law professor when I was in law school, so it is an absolute honor to get to be here today with him. Professor Percival is an internationally recognized leading scholar and teacher in environmental law. His distinguished legal career began in law school, where he served as the managing editor of the Stanford Law Review. He then served as a law clerk both in the U.S. Court of Appeals for the Ninth Circuit and then for the U.S. Supreme Court for Justice Byron White. He also served as a special assistant for the first U.S. Secretary of Education, and he went on to become a senior attorney for the Environmental Defense Fund. From there, he joined University of Maryland's law faculty in 1987. I'm going to list just a few more of his amazing accomplishments. His resume reads quite long. But in 1992, he was the principal author of the most widely used casebook on environmental law. He's authored more than 100 publications on topics that include environmental law, federalism, presidential powers, regulatory policy, and legal history. I'm going to skip over some of his many lectures that he's given around the country, but suffice it to say he has given hundreds of them in presentations and workshops in more than 30 countries on 6 continents. He represented the U.S. Department of State on a lecture tour of China, and he is currently on the faculty at a university whose name I'm not going to be able to say, so I'll save that one for you, and continues to teach around the globe. How was that?
That's wonderful, thanks. Nothing pleases me more than to see my former students do so well, and Mindy was one of the best students I ever had, so you're really lucky to have her here at Emory. I've been kind of a legal history buff ever since I ended up serving as a research assistant to Lawrence Friedman when I was at Stanford Law School. He's the guy that wrote the book, A History of American Law. And that really got me into legal history. And so a lot of what I want to chat with Mindy about today is sort of the history of how environmental consciousness in the U.S. has evolved and the way in which different industries and different types of corporations have responded to it.
Yeah. So with that, I'll get started. And I should say I'm clearly the environmental lawyer in the room and the only one not wearing a jacket. I did not even think about the fact that you guys dress up for things like this. And in developing our questions and answers, I kind of took the topic, we could cover it quite literally, and thought we would walk through examples of responsible and irresponsible corporate behavior first, and then go from there. So I thought we would jump off with the irresponsible side and have you talk a little bit about that.
Well, there's a lot to talk about taking the long view of history, particularly with respect to the asbestos industry, the lead industry, the tobacco industry, and the auto industry at times. If you look back over history, industries like the asbestos industry knew for decades about the deadly nature of their product, but their response was to try to cover it up rather than to warn anyone, confident in the notion that when people found out decades later, they wouldn't be able to hold them accountable. There's a great book by Paul Brodeur called Outrageous Misconduct that goes through the whole history of the asbestos litigation and how initially when, you go back to the 19th century, it's one of the topics Lawrence Friedman covers a lot in his History of American Law. if there were accidents, industrial accidents, and at a time of rapid industrialization, we didn't have nearly the concern for safety that we had. Initially, the response of many corporations was just to blame the worker. The worker caused the accident, put the blame on the victim. Then we had the development of workers' compensation legislation, which was designed to make it impossible for workers to bring tort suits against their employers. And the asbestos litigation that originally in the 30s, when workers started dying of exposure to asbestos in certain industries, they successfully kind of fended that off. And often one response was just, well, let's wipe it out by workers' compensation that barred the workers from suing the employer. And I think what you've seen, if you listen to Reuben Gutman talk, is a lot of legal innovation. And the legal innovation that took place in the 60s was the notion that instead of suing the employer, sue the company that made and supplied the asbestos materials because it was an inherently dangerous product. And as a result of that tort litigation, the most amazing discovery was the discovery of the Sumner-Simpson papers. The Johns Manville Corporation, which had been the primary producer of asbestos in the United States, had moved its corporate headquarters from New York to Denver. But they didn't realize that they had left behind a small cache of documents that belonged to the son of Sumner Simpson, who had been the corporate executive who back in the 30s had dealt with their insurance companies when their insurance companies were saying, your workers are dying at this incredible rate. And we think it's due to exposure to asbestos. And they actually had a study written up that was going to be published in the asbestos trade publication. And the Johns Manville executives killed it and said, no, we can't publish that. We can't let anyone know about that. And once those papers became available, that's what really triggered the punitive damages against Johns Manville that sent it into bankruptcy in the 1980s. The lead industry had a history that demonstrated the difficulty of environmental regulation controlling a substance that caused chronic harm over long periods of time. Physicians knew by the beginning of the 20th century about the lead poisoning problem. We were alerted to the problem of lead-based paint. The industry had a very successful strategy of controlling all the research, funding everyone who was doing research on the possible hazards of lead, and if they had results that didn't look good for the industry, just never letting them see the light of day. And then it was in the 1920s that the famous chemist Thomas Midgley invented tetraethyl lead. He's also renowned for having invented CFCs. And to his credit, he was very concerned about public health and safety. He tested all kinds of different compounds and rejected a lot of them for fears about the safety before he settled on tetraethyl lead, which actually was a great advance at the time because it enabled gasoline companies to very cheaply boost octane, which allowed for larger engines. And CFCs, which were invented around the same era, were a great advance in public health because the former refrigeration technologies had contained really toxic stuff that could be acutely dangerous. And it wasn't until a couple of scientists were doing the first environmental impact statement for the space shuttle program at the end of the 1960s that we developed this theory that CFCs were so stable they could work their way into the upper atmosphere and eventually damage the ozone layer. But with respect to lead, in the 1920s there were incidents at the manufacturing plant for tetraethyl lead in New Jersey that killed a lot of workers. There was a public health outcry, and the Surgeon General in the days before we had national environmental legislation said, let's bring all the experts together to decide if we should allow tetraethyl lead to be sold. There was one real public health advocate, Alice Hamilton, the first female professor at Harvard University who was in the School of Public Health, who testified that we couldn't prove that tetraethyl lead would greatly increase lead poisoning around the country, but we knew that it was going to result in a lot more lead getting in the air, which would be deposited in the ground, and couldn't but help increase childhood exposure to lead. But the tetraethyl lead manufacturer said, this is a gift from God. You can't prove that it's going to be harmful. They settled on doing a quick study for a 6-month study of filling station attendants at stations that sold tetraethyl leaded gasoline, and those that did not found no difference in their health, completely ignoring the threat of the emissions to children. And it was only, in the 60s that we started, as more and more tetraethyl lead was being emitted, realizing the real dangers of it, and that led to one of the most significant environmental court cases in the United States when EPA's first limits on lead in gasoline were initially struck down by a 3-judge panel and then upheld in an en banc 5-4 decision by the DC Circuit. And that's what ultimately led to our being able to phase leaded gasoline out entirely, which has now been adopted by virtually every country in the world. It's one of the greatest environmental success stories. Economists estimate that that's resulted in about $2 to $3 trillion in net benefits when you factor in all the improvement of public health around the world by getting rid of the tetraethyl lead in gasoline. Of course, you also have, it's a very well-known story about the tobacco industry, which for 50 years had a conspiracy to conceal the dangers of smoking, which involved things like creating their own phony research outfit to make it look like they were researching and very concerned about public health when they were really just trying to manipulate data. Fast forward to today, the federal government brought a racketeering-induced corrupt organization suit against the tobacco industry, and they're now legally required to take out ads that say that we had a pervasive scheme to defraud customers and potential customers, and that we intentionally designed cigarettes to make them more addictive. And you also have the master settlement agreement that was even before the RICO suit, where even though individuals could not sue the tobacco companies and recover because of the warning labels that were put on cigarettes, it was considered assumption of risk, the attorney generals of most all the states got together and said, cigarette smoking has cost us so much in increased health costs that we should be able to recover them. And the result was a more than $200 billion settlement by the tobacco companies. And now, even in the developing world, the dangers of tobacco use are well known, even though rates of smoking are still much higher there. We have the World Health Organization negotiated their first treaty ever, the Framework Convention on Tobacco Control, that's really made a big difference. Now, finally, I have to say, I thought this was sort of becoming ancient history. Corporations that, as two historians, Markowitz and Rosner, say in their book, Deceit and Denial, responded to potent evidence of the danger of their products by hiding information, controlling research, continuing to market their products as safe when they were known to be dangerous, enlisting industry-wide groups to participate in denying that there was a problem, and attempting to influence the political process to avoid regulation. But I was absolutely shocked when the Volkswagen scandal happened, because I naively assumed that most multi-billion-dollar multinational corporations, they have great environmental counsel. They're told what's necessary to do to comply with the laws, now that as a result of a lot of crusading scientists and the like, we've adopted comprehensive environmental laws on a national basis that are to ensure that our air is clean, that the water we drink is safe. I go to China a lot, and it's such a difference there. because even in the luxury hotels, you can't drink the tap water because the water's not safe to drink, and often you have a hard time seeing across the street because of the levels of air pollution. But I naively assumed that no major multi-billion-dollar multinational corporation would deliberately decide to violate the environmental laws. And I would recommend to everyone, if you really want to get the inside story of what happened in the Volkswagen case, go to Netflix. They have this Netflix series called Dirty Money, and it's episode 1, The Tale of Volkswagen. I just want to sort of go over a couple of the facts because it still blows my mind that this would happen today in the 21st century, that you would have a high-level corporate conspiracy to cover up deliberate violations of the environmental law. What happened was Volkswagen was being incredibly successful at marketing what they called clean diesel technology in the United States. People loved to drive these cars. They got good gas mileage, and they were told that they were doing a favor to the environment because the emissions from the cars were so green. And some scientists were skeptical about why they would have technology that could do such a good job of controlling nitrogen oxide emissions from diesel exhaust. And it turned out they did have the technology, but the problem was it required really expensive elements that would wear out every couple thousand miles. So it would be totally impractical for them to have the emissions controls turned on at all times. And it wasn't the government that discovered the defeat devices. It was an independent group, the nonprofit International Council on Clean Transportation, which commissioned a group that of what they call technology geeks at the University of West Virginia, who had the portable emissions measurement system, or PEMS, that actually allows you to find out what a car is emitting when it's on the road. What EPA and the California Air Resources Board typically do is vehicles have to go through these laboratory tests where the car's immobile, they measure what comes out of the exhaust. And what Volkswagen had done was they had designed the computer software so this very expensive emissions control technology would only be turned on when those tests were being done. And when these independent tests were done, the researchers the reason they were testing, they were convinced that this was a great technology and that there really was such a thing as clean diesel. And they were testing just to find out how good it was and to try to figure out how it was done so that more people could use the benefits of the technology. And yet their tests showed that the emissions were 40 times when the car was on the road over what they were in the labs. And at first they thought, there's got to be something wrong with our technology. They kept repeating the tests, same result. When they alerted the California authorities, they used this technology and tried the tests, and it was 80 times greater than what they had gotten in their lab. So they published the results without specifically identifying Volkswagen. They called it, Car A and Car B, although these researchers, and the irony is the guy who was behind all these tests for the International Council on Clean Transportation, his name is John German, and it was Volkswagen that he was dealing with. So he sent emails to Volkswagen saying, I'm presenting this paper at this obscure scientific conference in San Diego. You might want to be there because when I speak of Car A and Car B, they're both Volkswagens. And subsequent discovery when the federal government prosecuted Volkswagen showed that immediately emails went flying throughout the whole corporation. Oh my God, they're going to find out what we're doing. And they decided that their response would be to try to snooker the authorities and cover it up. They initially said, oh, there's something wrong with your for the diesel cars. So another thing that was discovered, and this is truly incredible because it's right out of the playbook of the tobacco companies. It turns out that Volkswagen wanted to have scientific evidence that the emissions from these supposedly green diesels were much better for public health than emissions from other cars. So they actually created a phony research organization and commissioned a scientist to, their initial plan was to have a human on a treadmill who would be breathing the exhaust from the diesels. They then realized that, it sort of smacked of maybe the gas chambers, and Volkswagen, with its history of being a company that Hitler initially lauded, they decided to replace that with a chimp. And the scientists didn't know that what the chimps who were watching cartoons while they were breathing in the diesel exhaust were breathing was not the normal diesel exhaust, but when the emissions controls were actually being used. So that was uncovered during discovery. Now, Volkswagen has reached a multi-billion-dollar settlement with the federal government. The corporation has pled guilty to 3 felonies, including not only breaking the Clean Air Act, but obstructing justice and illegally importing cars that were not what they were supposed to be. But we'll talk a little bit later about what's the appropriate way to deter this behavior. I think, just to jump ahead, this is one instance where criminal penalties for individual executives are absolutely essential. And in fact, they've indicted 6 high-level Volkswagen executives. One software engineer pled guilty early on, and they're kind of going up the chain of the executives. The problem is they've all fled to Germany, except one guy had a condo in Florida, and they caught him at the Miami airport when he was about to fly back to Germany. And he has now pled guilty to felony charges, but he's the only one currently being held in the United States. So I guess I shouldn't be so naive to think this kind of thing doesn't go on anymore in our major corporations. Let's hope that this is a total outlier and that the penalties that are ultimately imposed on Volkswagen will deter other companies from such outrageous misconduct.
Wow. Well, that was a lot all at once. And at the risk of us, or me, being accused of being cynical, I thought we'd switch to good corporate behavior first and then go back and, to the extent that we have time, talk about ways to deter bad and then encourage good. Because I do believe you have some examples of some folks doing the right thing, in fact, even more than what is required by the law.
Yeah, and I think the discussion this morning about corporate social responsibility, the paradigm has shifted so dramatically. It used to be that corporate executives would say, our only responsibility is to make as much money as possible for shareholders. But it's now become evident that even if that is your primary focus, the best way to do it is to have a good public image as a responsible corporate citizen. On both sides of the Atlantic, the notion of corporate social responsibility has now become embedded in the model of most corporations. And as Mr. McCarthy explained on the last panel, that means that instead of just shareholders, corporations are paying attention to stakeholders. They're paying attention to the ESG, the environment, society, governments, and the result is you're seeing a lot more proactive corporate responsibility, where one example of this is what's happening with respect to climate change. When President Trump announced that he was withdrawing the U.S. from the Paris Agreement, a group was formed called We Are Still In It, which includes hundreds of corporations saying we are making a corporate commitment that we're going to reduce our carbon footprint so that we can do everything possible to make the U.S. meet the pledge that had been made during the Obama administration when in December 2015 the Paris Agreement was signed. You're also seeing companies now that are trying to work with independent groups and NGOs to take this model one step further. And in response to concerns that a lot of this might just be greenwashing, to set up some consistent standards that will allow independent verification that what they say they're doing is actually being done, and in a way that will enable consumers to compare how well various companies are meeting these pledges. Some groups like the Sustainable Apparel Corporation have had companies contribute to hire independent auditors that audit the supply chain of companies that make jeans that have lots of suppliers in China and other countries. One story that I love to tell is what happened with Apple Corporation when a Chinese environmentalist, Ma Jun, decided that he wanted to figure out a way to use information to change the compliance of the suppliers of major multinational electronics companies in China, their compliance with environmental and labor laws. So we put together a coalition of 23 Chinese NGOs, and they audited the supply chains in China of the major multinational electronics corporations. And they discovered that Apple's Chinese suppliers were the absolute worst. They were hiring child labor, they were violating the Chinese environmental laws, right and left, and so they came out with a report saying Apple's supply chain is terrible. Now, the initial response from Cupertino, Apple headquarters, was we've got to ignore this and cite our policy. We never discuss who our suppliers are. It's a trade secret. So Ma Jun went, and the next year they did another report, which showed that they were even worse. Finally, Apple gave in. They flew him to Cupertino, and they agreed to hire an independent auditor who every year would go and audit Apple's Chinese suppliers in a way that would enable the employees to anonymously phone them. They would pass out cards saying, after work, call this number and we'll chat with you about what you've seen in the workplace. And now, every year, Apple publishes a supplier responsibility report where it shows you how many inspections were conducted by these independent auditors, how many environmental violations were found, what was the follow-up, because we're going to require our suppliers to correct these environmental and labor violations. And that's had a real impact without any litigation or law involved, just using the power of information. And the credibility of this not being the corporation auditing itself, but having respected independent auditors, it's greatly helped improve compliance with China's labor and environmental laws. And last fall, I woke up one morning, I had this email, I immediately skimmed it, and it said 100,000 euros, Royal Palace. So I thought it was some scammers. Turned out the Dutch royal family has the Prince Claus Fund that is always looking to honor social entrepreneurs around the world. And they were asking me to write a tribute to Ma Jun, who was going to be their 100,000 euro award winner that year. So in December, I got to go to the Dutch Royal Palace in Amsterdam, meet the royal family when Ma Jun got this award because of the ingenious things he's done, which also include he's designed apps on your iPhones where you can find out what the real-time data on air pollution is for PM 2.5 in 200 Chinese cities. And the public is really paying attention to this now, which is one reason why one area where the Communist Party, which is now tightening its grip on the Chinese government, has really gotten religion, is on cleaning up the environment. And you also see, efforts by Walmart, despite some other environmental violations that Ruben referred to. Walmart and Google have been reducing their carbon footprint. McDonald's just a couple weeks ago announced a major advance in how they're going to reduce their carbon footprint. This morning they announced in Beijing that they're going to reduce emissions in their Chinese operations by 50 million tons by the year 2030. So there's almost a competition going on now between some of these companies to see who can be greener in reducing their carbon footprint. Amazon is building wind farms all over, but they're the one major company that gets really low marks because they absolutely refused to provide information to the Carbon Disclosure Project, which is the respected independent auditor to make sure that these numbers are real, that these companies are bandying about. So you do see, a shift now where, back when the Rio Earth Summit was held in 1992, all the emphasis was put on what governments can do. Now corporations are recognized as being able to play a really hugely constructive role, so that even if we have a president who makes us the only country in the world now that's no longer going to be part of the Paris Agreement, although he can't legally pull us out until the day after the 2020 presidential election. So people are hoping that whoever wins that election will announce that we're rejoining Paris just the day before our pullout becomes effective. And the fact that corporations are picking up the ball and running with it is a really good sign.
Yeah, thank you. So I want to leave at least a minute or two for questions, but I always tell my law students that at a bare minimum, you want to identify the problems, but successful lawyers are those who can come up with some solutions for their clients. And so in the rare opportunity for the student to get to become the teacher for Bob, I was wondering if you could spend just a few minutes talking through what you think are some incentives to encourage corporate behavior, or some factors maybe that contribute to irresponsible corporate behavior that we could fix.
I mean, I think if you look back over these cases, there's no one thing that stands out, except probably the bottom line of all cases is that the company thought it would be better off not complying with the environmental laws than if they did comply, maybe because they weren't going to get caught. The tort system hasn't been very effective in dealing with products that harm people. Asbestos is an outlier because it causes signature injury. Asbestosis, mesothelioma, can only be caused by exposure to asbestos. Other pollutants, much harder to use the tort system. So they kind of made this calculation. In the long run, we're going to be better off economically. Now, part of that can be the penalties aren't great enough. And a great example of that was in China. It used to be that the laws specified the maximum penalty for violations. You could only be penalized for a single violation, even if it had been going on for months. And the maximum fine was so low that Xi Zhenhua, who was the head of the State Environmental Protection Agency in China, talked about how we really nailed a polluter with a maximum penalty of 100,000 renminbi, which is about $16,000. And the head of the company called him up and was laughing and said, hey, why don't we write you a check for 1 million RMB so it will cover our next 9 violations as well, because the penalties were so ridiculously low. Now that has changed. And in March of 2014, I had the unusual opportunity. I was called to testify before the Standing Committee of the National People's Congress because they were rewriting for the first time their basic environmental law, and a dispute had broken out. They wanted to make it more enforceable. The Ministry of Environmental Protection was saying, one thing we should do is authorize daily penalties. For each day of violation, the penalty increases. And the Standing Committee said, oh, that's way too harsh. And the ministry said, well, that's what the U.S. has done from the start. So the Standing Committee said, prove it. And so they said, okay, we'll bring American experts to China to testify. And so for an entire afternoon, we put together a team, a lawyer who works for, represents mining companies in the U.S., a public interest lawyer. I was the academic. We said, daily penalties have been a fundamental principle of U.S. environmental law. Why do you do it? It encourages companies to stop violating as soon as possible, so your penalty will be less. And so that almost everything we recommended was added to the law, and now you're finally starting to see some examples of where the penalties are going to be enough to deter violations in China, even though they still have a problem that so many of their companies are state-owned enterprises who think they're immune from any sort of punishment. Ultimately, though, the best way to incentivize good behavior is to have consumers that are really knowledgeable and are able to have information that's not controlled by a biased source that will enable them, when they make their own purchasing decisions, to take into account how good the company is as a responsible corporate citizen that cares about the environment. Ultimately, that will mean that companies will be better off economically if they're proactive in not only doing the bare minimum required to comply with the environmental laws, but having a vision of sustainability that they really carry out.
Couldn't agree more. All right, I think we have a few minutes left. If anyone has any questions, I think he'd be happy to take them. You answered everything. That's how you know you're good.
I'll just ask you to comment. Eric McCarthy mentioned earlier the letter by Larry Fink, CEO of BlackRock.
Mhm.
The ultimate penalty is when your shareholders walk,
Right, right.
And so increasingly, you're seeing shareholders who have an opinion about the ESG performance of the companies in which they invest. I just wonder what your comment might be on what you have seen, what you have heard. It's not just BlackRock, but you see other investors as well who have taken positions to say, we're going to reward those companies that have good ESG performance, and that ultimately is the incentive for the penalty for corporations to look after the interests of all stakeholders.
And I have to admit, this is another thing where I was shocked recently. I was kind of naive. Whenever I get the proxies for the securities I own, I usually just toss the ballot into the wastebasket because I think what good is my vote going to be? But you're actually seeing, I think was it Exxon, where the shareholder resolution this year on climate passed, got a majority vote from the shareholders of Exxon. I think Chevron now, they're consistently criticized because they have this liability in Ecuador that they've been going to war against the villagers whose environs were polluted long years ago. And the shareholder resolution on that, I think, got something like 39% of the vote. So you're actually seeing that being a tool for getting companies' attention. And that shows that, and that's actually encouraged me. I'm going to start voting those things now, because it used to be that I considered it hopeless, but that's something that does seem to be getting corporate attention. And you can tell, there's a whole spectrum of behavior from certain companies as to the, Exxon was always the one that denied climate change, did not have a great environmental record. Another was Shell, Royal Dutch Shell. And when I met the Dutch royal family, I got to sit at dinner with Prince Constantine, who presided over the awards ceremony for the Prince Claus Awards. And I said, why was Shell wasting so much money trying to drill in the Arctic off the coast of Alaska, when even BP said it's too risky to drill there? If there was ever a spill, there's no way we'd be able to clean it up. And he said, well, that's a private company, even though it has the name Royal Dutch Shell in it. So, I think companies will learn from their mistakes in some of these situations, and hopefully shareholders will keep paying attention to this. I certainly am going to in the future.
You want to call it? Yeah. I think so. I think that might do it. All right.
Thank you so much, Professor Percival, for coming.